Welcome to the EFA Fiduciary Training Series. My name is Tom Baston, and the goal of this program is to educate our committee members on their duties and responsibilities. The Department of Labor has recently started asking for proof that committee members have been trained and understand their responsibilities as plan fiduciaries. The combination of watching these videos and executing the committee member acceptance letter will document your adherence with government expectations. Each video is about 5 minutes long, and they've all been divided into 4 groups. We will indicate which group to watch each quarter until you've seen the entire series. It is very important that you complete the registration at the end of the video. So let's get started with Module 1, Fiduciaries. In this module, we will be defining the term fiduciary as well as identifying the various types of fiduciaries involved with your plan. It is important to understand what acts are considered fiduciary in nature versus functional so you can properly identify when a fiduciary exists. A fiduciary is any individual or entity that has or exercises discretionary authority or control over the management or administration of a plan or the disposition of plan assets. For example, the company's board has discretionary authority regarding the company's plans, and therefore its members are ERISA fiduciaries with respect to the plans. Members of a benefits and/or retirement plan committee are also ERISA fiduciaries. A plan may have more than one fiduciary, and if the plan so provides, an individual or entity may serve in more than one fiduciary capacity. Advisors who provide investment advice for a fee to a plan fiduciary who makes the investment decisions are also fiduciaries. Fiduciaries do not include any individuals who only perform ministerial functions and do not have the power or authority to make decisions with respect to plan policy, interpretation, practices, or procedures. For example, an individual who calculates benefits, processes claims, or makes recommendations about plan administration is not a fiduciary if the plan document does not give him or her the power or authority to make a decision about benefit payments or recommendations. The test for determining fiduciary status is a functional one. For example, any person or entity that exercises any discretionary authority or control with respect to the plan is considered a fiduciary, even though such individual or entity is not named in the plan document. Generally, members of an employer's board are fiduciaries to the extent that they function as fiduciaries, meaning they have or exercise discretionary or authority or control over the management or administration of a plan or the disposition of plan assets. For example, this could occur if the board selects and retains other plan fiduciaries for the plan. Non-board and non-voting members are fiduciaries only if they have authority along with the regular board members to exercise fiduciary functions. A number of a plan sponsor's decisions affecting ERISA-covered plans may not be considered fiduciary functions because they are business decisions. These are known as settler functions. For example, a decision to establish a plan, to include certain features in the plan, or to terminate a plan are considered business decisions. In the process of making these decisions, the plan sponsor is generally acting on behalf of the business, not the plan, and therefore would not be a fiduciary. However, a plan sponsor, or someone hired by the plan sponsor, who takes steps to implement these decisions, such as a plan termination, is acting on behalf of the plan, and in carrying out these decisions is a fiduciary. Each plan must have at least one named fiduciary who serves as the plan administrator, and if assets are held in trust, at least one trustee. Named fiduciaries are those individuals or entities named in the plan document or identified in accordance with the procedure described in the plan document. A named fiduciary may be identified by name or by title. A named fiduciary can be the plan sponsor or an officer or other employee of the plan sponsor who reports to the plan sponsor's board or management team. Generally, named fiduciaries may allocate responsibilities among other named fiduciaries, or named fiduciaries may designate other individuals to carry out fiduciary responsibilities, but only if the plan document permits the allocation or delegation of fiduciary responsibilities. A named fiduciary may not allocate or delegate his or its responsibilities related to the management and control of plan assets unless the named fiduciary allocates or delegates such responsibility to an investment manager. A fiduciary who allocates his responsibilities or designates another to carry out his responsibilities must take appropriate care in choosing a designee and must also regularly monitor such designee's performance. Such designee is also a fiduciary. If the terms of a plan document allow named fiduciaries to allocate their responsibilities, then a named fiduciary is not liable for the acts and omissions related to those responsibilities allocated to another person or entity. A co-fiduciary may, however, be liable for another's breach of fiduciary responsibility if the co-fiduciary has either participated knowingly in or knowingly undertaken to conceal an act or omission of another fiduciary, knowing such act or omission is a breach, enables another to commit a fiduciary breach, or has knowledge of a breach committed by another fiduciary and fails to make a reasonable effort based on the facts and circumstances to remedy the breach. If the terms of the plan document do not provide a procedure to allocate fiduciary responsibilities, then a named fiduciary is still responsible and/or liable for the performance of those fiduciary responsibilities performed by another person or entity. In summary, individual co-fiduciaries may bear the majority of liability with overall plan management and performance. Members of an employer's board are fiduciaries only to the extent that they function as fiduciaries, meaning they have or exercise discretionary authority or control over the management or administration of a plan or the disposition of plan assets. For example, a board that is responsible for selecting and retaining plan fiduciaries is considered to be exercising discretionary authority or discretionary control respecting management of such plan, and is therefore fiduciary with respect to the plan. However, the board member's responsibility and liability are limited to the selection and retention of fiduciaries unless they become liable under the rules for co-fiduciaries. Furthermore, if any of the board members are named fiduciaries, their liability may be limited in accordance with the plan document if it contains a procedure allowing named fiduciaries to allocate their fiduciary responsibilities. Members of a benefits and/or retirement plan committee are fiduciaries if the committee is allocated fiduciary responsibilities. The benefits and/or retirement plan committee, therefore, should carefully document all meetings where actions are taken with respect to management and control of plan assets and management and administration of the plan. Written meetings should describe the action taken and should also state how each member voted on each action. If any members object to a proposed action because it might violate ERISA's fiduciary standards, then those members objecting to the action should insist that their objections and responses to their objections be documented in the minutes of the meeting. A member can resign in protest against the fiduciary breach of another member. However, the resignation may not be sufficient to discharge their duty to make reasonable efforts under the circumstances to remedy the breach. Trustees, other than directed trustees, are fiduciaries and therefore should carefully document all meetings where actions are taken with respect to management and control of plan assets. Written minutes should describe the action taken and should also state how each trustee voted on each action unless the decision has been delegated to a discretionary fiduciary. If any trustees object to a proposed action because it might violate ERISA's fiduciary standards, then those trustees objecting to the action should insist that their objections and the responses to their objections be documented in the minutes of the meeting. Employees of the plan sponsor or employees of other plan fiduciaries are not necessarily plan fiduciaries themselves, depending on the individual facts and circumstances. Generally, an investment manager is a fiduciary if they meet the requirements of ERISA Section 338. An investment manager must acknowledge in writing that it is a fiduciary and either be a bank, as defined in the Investment Advisors Acts of 1940, an insurance company qualified under the laws of more than one state to manage, acquire, and dispose of the plan, or investment advisors registered under the Investment Advisors Act of 1940, which EFA is. Generally, attorneys, accountants, actuaries, and consultants performing their usual professional functions are not considered fiduciaries. However, such an individual would be considered a fiduciary if, based on the facts and circumstances, the individual exercises discretionary authority or control over the management or administration of a plan, or the disposition of plan assets, or renders investment advice for a fee. Many consultants and third-party administrators whose plan fiduciary clients rely on them in a very significant manner when making fiduciary decisions may also be acting in a fiduciary capacity. Individuals are prohibited from serving in a fiduciary role on ERISA plans if they've been convicted of or imprisoned as a result of said conviction for these offenses listed below. Plan sponsors must select and monitor fiduciaries for their plan. Selection should be based on experience and expertise, not title. It is also important to monitor the interactions between the plan and parties in interest. The Fiduciary Fitness Program helps make it easier to monitor all parties involved with the plan and bring the necessary procedural prudence and documentation ERISA and the DOL require. That concludes this video. Please make sure to complete the registration that follows. Have a great day. For additional information, you can contact us at this toll-free number or via our website.